Now we've talked about how mediation starts, okay? The session. The mediation session is where party A states their case, party B states their case. The mediator tries to facilitate a favorable negotiation, and then they reach a compromise. So we've talked about the session, we've talked about compromise. Compromise just means, letting some things go for some things to happen. So I've used an example in the other video, and let me also use the example of land dispute. For instance, you are the buyer and here is the seller. Here's a third party claiming that the land belongs to them. So after we have done the mediation, we have now realized that actually the land belongs to the third party, not to you who sold, and now by implication not to the complainant who brought the matter. So what's going to happen? Compromise now will happen in that you who has emerged as the real owner of the land, what do you want to do for these parties? Do you want them to rebuy the land from you, or do you want them to upstand, maybe pay some amount of money and then you give them the land? Or if they have built something on the land, do you want them to uproot what they built, or do you want to buy what they built from them? What do you want to do for them? So you can say that I have no business with you. Go and do whatever you want. The land is mine. If that happens, it becomes between the seller and the buyer. So you seller that sold a wrongful, invalid title, what do you want to do for this third party, this innocent third party purchaser? Okay, I will restore them to status quo ante bellum. That is, I'll return what they paid for the land. And now this person might be saying that I bought this land as an investment. It was 500,000 per plot when I bought it in 2016. This is 2022, and it's now 1.3 million naira per plot. Lands sold in that area. So you can't just say you want to return 500,000 naira to me. I want 1.3 million naira. Also, I've done CFO, I've done the survey of the land. I've put corner pieces. I've even started a foundation. And I'm going to lose all of that? No. You can't just give me 500. So we go back, what do you want to do? And then this person says, okay, I actually understand. I understand what is going on. Actually, you can see that I sold wrongfully believing that the land was mine, which is the case. The case is that the person will now admit that, okay, actually, the land does not belong to me. I'm sorry for misleading you and selling to you. Or maybe they will say that it's someone that sold to me too. So we write a further letter to invite that other party. So why did you sell to this seller an invalid title? So then we continue and continue. Or if they are open to what the buyer is asking for, okay, I can't give you more than 700,000 now. I'll add 200 to the 500, so 700. So from 1.3, okay, give me 1 million naira and let's forget about this. No, I'm saying 7, even that 700, I'm going to pay it in tranches. I can't just pay everything. I don't have money now. What do you want to be my own gain to? There's nobody, you know that things are tight right now. You're not the only person I sold to. I have to reimburse other people that I also sold land to in that area. Okay, make it 800,000. I'll make it 750. That's a bargain. That's compromise. So I'm trying to explain compromise here. That's another terminology that's very frequently used in mediation. So that's compromise. Then we come to, okay, 750. Then we do an MOU. That's a Memorandum of Understanding. Memorandum of Understanding is another terminology. And it means that what the parties have agreed to, we reduce it to writing. And then we state some of the guiding principles that will guide the execution of that agreement, such that some things like we put the name of the parties, name of the mediator, the mediation center. Then we write things like, okay, the mediator cannot be summoned to give evidence if this case goes to litigation, because his conduct in this case is without prejudice. His conduct is immune, because he's only acting in his role as a mediator. He cannot serve as a witness for any of the parties if they go back to litigation. We can put something like that as one of the guiding principles, or the terms of the generic terms now, not the terms that parties have agreed to, the generic terms. Of course, party will read and sign everything. Then we can put things like, if any of the party defaults, then they are subject to being dealt with by the force of law, or that the law can enforce these agreements as necessary. So many rules, so many rules and so many guidelines. And then, of course, we talk about what parties have agreed to do. And then there's a space for the Commissioner for Oath to stamp it and all of that. So that's a Memorandum of Understanding. Basically, what you've agreed to do reduced into writing with guiding principles and terms. Okay? Another important terminology in mediation is caucus. Caucus, in fact, we have a caucus room at our center. Caucus means that when things are getting hot, because I explain this every time to parties, because parties can be very funny. One time I tried to do caucus with a party. I explained to them that, okay, party A, you now excuse us. Okay, caucus means that when things are getting heated, or you have reached a gridlock, but you can see that there's still a possibility of settlement in this matter, you tell one party to excuse you, and then you talk to one party alone. You counsel them, you encourage them to, reduce the tension, just to douse the tension generally. That's what you do. Then you discuss the terms and conditions that they want with them. Then you invite the other party in, you send them out, you invite the other party in, and then you also talk to them. You try to go over their own terms and conditions to see which one they can throw away and which one they can come down on, which one they can increase, and what they generally want. So while one party is outside, they wait for you in the caucus room or a waiting room. They will not go away or leave for the day while you talk to the other party. Usually caucus takes about 5 to 10 minutes, but we've sometimes had caucuses that lasted for like an hour. I remember I was co-mediator in a matrimonial matter. My superior was doing that matter, and I think we caucused with the woman for about an hour before we called our husband in, or maybe we caucused with our husband first for about 30 minutes, then the woman about an hour, but we still could not reach a settlement. So it's not all mediations that end in amicable settlement. Some will just reach a gridlock. Then we advise parties to explore other legal means of settling their disputes. But that's what caucus is. So I remember in this inheritance case, these sisters and a brother, I think, yeah, they brought one of their brothers who they accused of usurping the property of the father. The father had a property, a large building with several rooms, and he had died intestate, so they were fighting over the administration of that property. They were saying that the brother was collecting rent and was not remitting it to the entire family and all of that. So they wanted a neutral agent to come and, start administering the property and all of that. But the caucus that happened was that I told the complainants that I wanted to caucus. I told the respondent to excuse us while I caucused with the complainants. Okay, so the respondent, instead of going into our waiting room or the caucus room, he stood outside opposite my door, my mediation room door, and he was watching us. But we continued to discuss. So when we finished, I told them to excuse us, and then I called in the respondent. I started caucusing with him, but it was a pepper body kind of person. So as he was talking about his sisters who were older than him now, he was pointing at them, and they were also standing outside instead of going into the room. He was into the caucus room or the waiting room. He was pointing at the woman. So I thought that this might cause a fight, even though he also stood there when I was caucusing with the sisters. Now he was pointing at them and saying very explosive things that were incendiary in nature, so I had to go close my door. That was an offense. I did not know. So when I finished caucusing with him, I asked his sisters to come in. That was how the one that stood by my door, when I closed the door, she said as she's coming in, that respondent should leave. I said, but I caucused with you, and then I caucused with him. She said, no, when you were talking to him alone, you closed the door. So he must also leave while you are talking to us. I said, no, it's a caucus. I closed the door because he kept pointing at you. I didn't want you to get angry because of the things he was saying. She was so angry. She was trying to say that, oh, we don't even know how you are doing this, your mediation. We came here thinking that you would do this. So, I said that because some people come with their own decisions in mind, just expecting you to rubber stamp it for them. No, we don't do that. So we eventually had to reach a compromise that another person, another sibling should, do some things, and then we adjourned for a report of progress, and so on and so forth. So that's what caucus is. So things can get heated. I think it was that same mediation, a sister slapped the brother. Sometimes they start shouting at each other. A lot of things can happen. So caucus is the means by which you douse the tension as a mediator. Very important. Also, signing the MOU at the end is very voluntary. Do not force parties to sign an MOU that they have already decided they will not comply with. They need to sign something that they will do, something that they are okay with, something that they have decided to comply with. You can urge, persuade, and help them come to an understanding. But until they come to that understanding, do not assume and do not make them sign something by force. Because they will go out there and say, oh, the mediator made us sign it, we didn't understand what we were signing, and all of that and all of that. That's very important. Another important thing is that in doing an MOU, our terms must be one, certain. That is, are you moving out on the 10th, on or before the 10th of January 2023? Not just like maybe any 2 weeks from now, or when you have the money, or when you find an apartment. No, the terms must be certain. 2, the terms must be doable. They must be practicable. You cannot write in an MOU that the father of 4 children, who is now separated from their mother and who is a vulcanizer by profession, should pay 100,000 per month for the upkeep of the children. Where is he going to find it? So the terms must be doable. Remember that the law will not compel an impossibility. That's a maxim of law. Now, a mediation session or center or parties must not also agree to an impossibility. So the terms must be doable. The third thing is that the terms must be fair. The terms must be fair, okay? So it's not about law. You know that in the court of law, based on technicalities, the victim might not get justice, and the perpetrator can go scot-free based on technicalities. That's not so in mediation. In mediation, the terms must be fair. It must be fair. It must be that this person, okay, you took a loan, you didn't pay it back. This is your creditor who is here, who is complaining of how you're not paying it back, has cost him his job, or maybe your guarantor has come and is complaining of how they've taken over his collateral because you didn't pay up your loan. We must come to an agreement that is fair to this person that's put their life, their property on the line for you to take a loan. And we must also come to something that is fair for you. If it could be that maybe things are no longer okay with you and you can't even afford to repay the loan now. So we need to look at what is fair, what is doable, and what is certain to reduce it into writing in our MOU. Very important. One other thing that we have to talk about is the present parties during a mediation. Ordinarily, they should be the respondent, the complainant, and the mediator. But sometimes they come with friends and cronies and lawyers and what have you. So if someone asks, when parties sit down, one of the first things that we ask them is, who is the complainant, who is the respondent, who are these other persons? Sometimes they say that this is my daughter. Maybe she had nowhere to stay, so I had to bring her along. Is she underage? Is she connected to this matter in any way? If she's underage, if she's not connected to the matter in any way, or if her presence is going to, not be okay for her by children's standards, we send her to the waiting room. Let her go and stay in our waiting room. It's safe, it's okay, it's comfortable. Okay, nothing will happen to her while you're here. Is this person your friend? Why is your friend here? Are they a witness to, your husband's battering of you? Do they have anything to say in this matter that will not, worsen the case? Okay, let them stay. Is this person your father? Your father-in-law who gave you the wife? Okay, let him stay. Is this person your lawyer? Lawyer, please, we need you to understand that this is not a law court. So you are not here as a lawyer. You are here as a co-mediator because you are our colleague. So we expect you to help us facilitate the process, even if you're already biased, because you came with a party. And if the lawyer is going to make things difficult, we excuse the lawyers. Please excuse us. I've done it before. There was one time the lawyer was making things so difficult for us. He kept on interjecting, kept on wrongly preempting us. I had to put my foot down because I was co-mediating with my colleague. I told them, I'm no longer doing this mediation. No, I'm not continuing with this mediation. Every other thing they said, I kept quiet until the lawyer left. I said, if this lawyer does not leave this place, I'm not going to do this mediation. So when he left, we had to also tell the lawyer of the other party to leave too. Stay in the waiting room. Wait for your clients, okay? Let's talk. Let them come to an agreement themselves. They are human beings. They had a relationship, was landlord and tenant. They had a relationship before you came into the picture. Let them sort whatever is between them. Best believe that these people sorted their differences as soon as their lawyers were out of the door. So very important. So if you are a party that is following your friend, your crony, your daughter, your father, your mother, your colleague in mediation, or you're a lawyer following your client to mediation, you have to actually be pro-mediation. Don't think that, oh, I'm going to go and show them Pepe. Where have they taken you to? Mediation center. What can they do? They are toothless bulldogs. They don't have power to compel. They don't do, because we have lawyers, people saying all manner of things. Okay, so the mediator's job is a job that requires a lot of patience. So if you are following someone to mediation, you have to actually be pro-mediation. Don't come with, your pre-decided point of view. Come with an open mind. Okay, that's very important. If you're a lawyer, most especially, don't bring law into the matter. Let's talk amicable settlements. Don't bring law into the matter, please. Also, stop acting like you're trying to sabotage the mediation because you're afraid you'll not be paid. If you're a lawyer that is accompanying your client to mediation, let them understand that they have to pay you as if you were also going to court for them. ADR is supposed to be paid. It's not pro bono. It doesn't mean that you are losing your revenue as a lawyer. Please, very important. So don't act like, oh, I'm going to keep getting in your way so that I can get money from this person. I know that I was co-mediator in another labor matter, discharge of employee with a foreign company in Nigeria and all of that. And the lawyer was so difficult that we had to confirm within ourselves that is this man afraid that he will not be paid? Is he not going to be paid? So very important, very important. We had to even do caucus at some point so that we let the man understand that the way this mediation is going is in your favor. Your former employers have come to the table. Let peace reign. Lawyer, please calm down and let's move ahead. So if you're a lawyer, please be pro-mediation, or if you're any party following another person to mediation, please don't be the person that will come and add insult to injury, or that will come and bring Pepe body. Okay, there was a time I was doing a mediation. It was a foreign company also, a matter of employee discharge. The man had resigned. He was claiming some entitlements and all of that, and the wife was so angry. She was raising her hands to talk. I said, madam, I won't allow you to talk. You are angry on behalf of your husband based on what your husband has related to you as transpired in the company. At the end of the day, we found out that the man had misrepresented the position, because when the foreign CEO now explained the true position of the matter and confronted the man with evidence, it turned out that the man had been, giving us half-truths from the start. So it was a really good call for me not to have allowed the wife to speak, because she was angry at that point on behalf of her husband, and she would have, made things worse rather than get them better. So very important. The mediator's job is to, make the right calls. So very important. So those are things that I want to explain. In subsequent videos, we're going to talk about the benefits of mediation. We're going to talk about the qualities of a mediator, and we're going to talk about some very important, useful tactics for mediation. I hope you watch till the very end of this series, and I hope you tell a friend to subscribe to Battle with Ola, watch the mediation series and every other series. Don't forget, guys, if you watch till the end, the better off for the channel. Thank you so much. I'll see you in my very next video. Toodles.